Okay. Hello, everyone. My name is Adam Kardash, and I'm the co-chair of Osler's National Privacy and Data Management Practice and national lead of AccessPrivacy, Osler's thought leadership platform. On behalf of the Canadian Anonymization Network, or CANON and AccessPrivacy, I want to welcome and thank you for attending this webinar consultation session on the draft de-identification guidance issued by the Office of the Information of the Privacy Commissioner of Ontario. As many of you are aware, CANON is a not-for-profit organization which consists of large data custodians from across the country in the public, private, and health sectors. And if you haven't done so already, we encourage you to visit the CANON website at www.deidentify.ca. As stated on the website, one of CANON's core publicly stated objectives is to advocate for balanced legislative and policy standards for anonymization. And through our advocacy efforts, we carefully review and engage in multi-sector consultations with a view to ensuring that legislative schemes, regulations, proposed regulations, and published guidance, draft guidance, enable innovative and beneficial uses of data while reasonably protecting against foreseeable privacy risk. We ensure that definitions and concepts within those instruments are defined in clear, crisp manner and easily understood. And we ensure that the language is drafted in flexible, principle-based, technologically neutral, and sectorally agnostic fashion. Critically, we take steps to ensure and offer comments to ensure that the instrument is actionable and specifically not overly burdensome, doesn't raise unnecessarily prescriptive or costly measures, especially the case for small to medium-sized enterprises. And overall, as I just mentioned, we seek to ensure that the legislative or policy instrument that we're commenting on ultimately serves to foster trust, while at the same time facilitates the responsible leveraging of data for beneficial purposes. So through this lens, Canada has conducted consultations on the de-identification and anonymization concept in proposed legislative frameworks within Bill C-27 and the anonymization regulations under Quebec's Reformed Private Sector Privacy Law. Today, CANON and AccessPrivacy are pleased to be co-hosting this workshop on the detailed draft de-identification guidance that's been issued by the IPC. All attendees received a copy of the draft guidance upon registration for the webinar. As you will have noted, the draft guidance consists of 11 fact sheets and builds on the IPC's 2016 de-identification guidelines for structured data. And that guidance has been very well received and remains a core guidance to this day within the Canadian privacy arena. Our sense is that the final version of this IPC guidance that we'll be discussing today will be informative and potentially quite impactful for stakeholders across the Canadian privacy arena within the public, health, and private sectors. In large part, this is because the IPC has been at the forefront of Canadian privacy regulatory authorities with de-identification guidance for years. And notably, the draft guidance has been authored with the detailed input of Khaled El-Imam, who is currently a scholar in residence at the IPC, and as many of you are already aware, one of the leading authorities globally in the de-identification and anonymization space. So right now, the IPC is currently holding a consultation on this draft guidance. And as part of the IPC's consultation process, CANON was solicited for feedback on the draft 11 fact sheets. Now, if you haven't done so already, I encourage attendees to familiarize yourself with the structure and substance of the draft guidance during the course of this consultation webinar. As you'll note, the fact sheets are over 50 pages in length in total, which is quite lengthy, and it covers a range of topics. These include de-identification terminology, general principles of de-identification over a couple of fact sheets, concept of managing risk of de-identified data. There's a checklist for evaluating de-identification documentation, and a fact sheet relating to activities before and after the de-identification process. And again, there's 11, so there's several more. Now, we're conducting this session to provide feedback to the IPC as part of their consultation process. And we're going to be doing so in a manner consistent with the approach CANON took during the consultations, our consultations involving Bill C-27 and the Quebec government's draft anonymization regs, and similar also to the approach AccessPrivacy took in various contexts, including the ISED code for generative AI. And during this 2-hour session, we'll be discussing key features of the draft guidance and its practical impact, all with the view of obtaining comments from webinar attendees as well. And the discussion will take place over 2 parts, each lasting about an hour or so. The full webinar session, including comments and feedback from attendees, will be recorded, and a copy of the recording, together with a summary of key themes arising from the discussion, will be submitted to the IPC. During the first hour or so, I'm going to moderate a panel featuring 3 representatives from CANON Steering Committee, each of whom has extensive experience and expertise in one or more aspects of de-identification and anonymization, and just generally in the privacy space. We're real privileged to have 3 just leading experts. Specifically, Pam Snively, who is the Chief Data and Trust Officer at TELUS Communications and TELUS Health; Suzanne Moran, the VP of Enterprise Conduct, Data Ethics, and Chief Privacy Officer at Sun Life; and Marianne Vermeulen, Senior Director of Research and Data and Financial Services at the Institute for Clinical and Evaluative Sciences, or otherwise known as ICES. On our session today, we also have several representatives from the IPC. They're going to be attending this consultation workshop merely as observers. Following the roundtable discussion, as mentioned, we're going to open up the session to attendees, and my colleagues Caitlin Smith and Catherine Hart from Osler will help receive and shepherd the comments and questions that we receive for discussion. And just before we begin, a couple of administrative points. We're encouraging attendees, actively encouraging attendees to provide comments, and you can do so via the chat function on the chat icon at the bottom of the page. Once you click on that, a chat box will pop up in which you can type your comment. And please do so throughout the conversation. These comments will be made available to the IPC. Of course, all comments are welcome, especially specific actionable recommendations for the improvement of the guidance. We also encourage live comments from attendees, which will take place in the second part of the session. So with that out of the way, let's begin. First of all, Pam, Suzanne, Marian, thank you all for joining us and for the considerable amount of time I know that each of you have taken to prepare for this session. And to kick off the discussion, I'd like to turn to Marian. Marian, you've had time, like Pam and Suzanne, to carefully review and consider the 11 fact sheets. As an initial query, and then we'll turn after this to each of Suzanne and Pam, but Marian, what did you find beneficial about the proposed guidance?
Thanks so much, Adam. And can you hear me? I've had some audio issues myself.
I can hear you, and I can't see for sure, but just click the video as well if you're not on.
Yes, I've been trying to click the video and it's not working for me for some reason. I'll try to fix that momentarily as well.
Audio will work.
Certainly appreciate the opportunity to weigh in. And, you know, I think that these fact sheets provide a very comprehensive and detailed guidance, particularly on some of the more technical aspects of the de-identification process, and certainly saw them as beneficial from that perspective. I did really appreciate the efforts to ensure that we're speaking the same language and ascribing the same meaning to various terms at the outset. You know, it's a complex topic, and I think that's really important from a level setting perspective. And I also appreciated the efforts to cross-reference information within the guidance and with the previous de-identification guidelines. It's a lot of information to navigate, and that's certainly important. And You know, similarly, those key takeaways at the end of each of the fact sheets, you know, just given the length and the density of the document, I thought those were a helpful summary. I also did, you know, appreciate the aspects of the guidance that took a measured approach in terms of noting the importance of context, identifying what is generally realistically possible in certain situations, and providing alternatives in some cases. And then for some of the more technical concepts, I thought that the use of examples to illustrate and walk through those was quite helpful. And I think that would be particularly true for those who are new to de-identification. And I guess finally, just as a footnote, I thought it was interesting that there was a fact sheet on synthetic data. And although, you know, I'm not sure how commonly this is used, I do think that this is an approach to making de-identified data more widely available that's of growing interest.
Thanks. And the one point you measured about this measured approach, there's specific statements, and I'm sure Pam and Suzanne are going to comment on it, but there's this measured approach, I don't think could be overstated. There's some really helpful statements in there. If folks can look at the key takeaways in fact sheet number 2, for instance, where there's a clear statement that zero risk of re-identifiability is not a standard that could be operationalized in practice. That's really welcome language from a regulatory authority, especially one that has large input of one of the global leading authorities in the area. There's an express reference measured as well, contextual context, that public and non-public data sets require different approaches, and that controls need to be taken account as part of the risk assessment. So you have those measured and contextual considerations, and I couldn't agree with you more, Marianne. Maybe we'll turn now to Suzanne. What did you find beneficial, Suzanne, when you went through the documentation?
Yeah, so Adam, I actually just want to pick up on what you were talking about just now with the measured approach and the contextual statements that are included in the fact sheets. Like, I think it's critically important that context is actually reflected in these fact sheets because there's just a panoply of uses, right? And to be really explicit about internal versus external use, to be really explicit about the purpose of the processing. You know, there could be a lot of different reasons, right? It could be for internal safeguarding purposes as well. Real mention of other mitigating controls. Those controls can include administrative controls, sometimes referred to as soft compliance, right? Application of your code of conduct and things like that. Both security and physical controls, where you might get into actually what I like to call hard compliance, where technology, you know, could actually be in place to manage some of those risks. And then I'll mention as well of contractual provisions that might be included. You might even internally use NDA. So, you know, referencing that whole panoply, if you like, of other mitigating controls. And, you know, maybe the last thing I would say, as, you know, a proud supporter of CANON, it connects quite nicely to some of the other work that CANON has been doing in this space around making sure that, you know, legislation and guidance also reflects what we've seen in jurisprudence around reasonableness in the circumstances when it comes to context. And so, you know, connects quite nicely to some of the advocacy work that CANON has been doing together as a very broad multi-stakeholder group. And maybe I'll stop there.
Pam, your feedback.
Yeah, thanks, Adam, for this opportunity. So like Suzanne and Marion, I really deeply appreciate the effort that's gone into this and the attempt itself, because I think this is a subject which I think you and many other people maybe on this call know is near and dear to my heart. For a lot of the reasons that you outlined in the introduction, just how critically important it is for us to be able to leverage this as a tool to be able to get the value out of data while respecting privacy. what I like about this attempt is that it drives home the diligence that's required. So, you know, that really, it counters the argument that's out there that this is easy and is an easy out for industry or government or researchers, and really doesn't protect privacy. I think it shows this is almost a science essentially, and there's a real science and art to it. And I appreciate that because I think that's really important for us to give comfort to people whose data is included in these types of data sets, to show the diligence that's required, and that there are increasingly these sort of objective steps that can be taken, that this isn't just what TELUS decides is sufficient. It is, you know, a standard that's out there. And so any attempt to create, you know, standardization here is so appreciated. I also appreciate the other side of this, which is, you know, just the very existence of this, and you've kind of highlighted this, the reasonableness, but also just the fact that this is not impossible. That there's also a voice out there that is saying it's really impossible to do this well. And so I think this is a really great document that shows us, you know, it's possible to do well, and there is a way to do it well. When I look at guidance like this, I look at how I can practically use that within my organization. And what I'd say is, when I look at this, you know, and it's emphasized a few times that it is to be combined with the existing IPC guidance, and you mentioned that as well in your introductory comments. I would say that, you know, if we took this document together with that original the IPC existing guidance, I would say everything we need for us to prepare a standard, for example, internally for TELUS is there, or just about everything we need. Like in terms of, you know, what are the steps that need to be taken? What are the considerations that need to be made? All of those items are in these two documents. And so that's super, super helpful. There's a tremendous amount that's there. So the question is whether or not everyone can digest it as it's presented, and maybe we'll talk about that a little bit more in some of the suggestions that we might make. But what I can say is that when I combine this with the existing guidance, if I were to pass this to the people in my organization who are going to be de-identifying data, or even just using de-identified data, or designing systems that will rely upon de-identified data, I can have a very high degree of confidence that if they can read and digest this, they're going to get it right. And that's really, really important and super, super helpful. So I think I'll stop there, and we can get into the suggestions after that.
Sure. So let's turn to the second part. And Suzanne, I'll turn to you to start. IPC is seeking comments. So let's have a discussion now with the panel, and I think this will be the bulk of this first part, about what feedback, other consideration, or challenges came to mind when you reviewed the set of draft fact sheets.
Sure. Thanks, Adam. And I'll maybe go a little bit on the light side for some of the challenges. And, you know, when Pam was sort of speaking about everything is there for their organization, a mature, proactive organization like TELUS, but also needing to keep in mind, I think when you read through all of these, there's a lot. It can feel very heavy, and also depends on the size and the maturity of the organization. So while everything may be there, maybe just in the way that it's presented, it feels very heavy. So also connecting back to the comment I said before about how it's really critically important, and that's definitely one of the pluses in this great piece of work, is the context and how context matters and the reasonableness. So making even clearer, I think, in these fact sheets that it can be done in different ways, and that organizations can tailor it to their own sort of governance and their own sort of processes. For example, you know, organizations can leverage their privacy impact assessment process if PI is involved, because it often is a great way to de-risk the processing of personal information. And so I know at Sunlight, for example, we leverage our PIA process quite heavily to de-risk our use of personal information. So making it clear that it need not be necessarily one thing that's all separate and standalone to the side, but you could incorporate it into other processes or governance frameworks that you might have. Also making it sure that it can be used in a very broad spectrum of cases, like I mentioned before. This isn't just about leveraging de-identification in the context of it making data sets available externally. To be honest, most of us don't do that, may never do that, but it's also about all the advantages that can be leveraged from de-identification or different levels of it in the context of internal uses. So making it really clear that, hey, this is equally important for you to use for your own processing of personal information, to do so in a more de-risked manner, whether it's for safeguarding or part of your data minimization efforts at the end of life cycle, maybe, right? If you're choosing to truly anonymize information rather than deleting it, sort of making it clear that these steps can be used tailored to whatever the actual process might be. It's not just about big data sets being made available publicly, externally. Those are probably just the tip of the iceberg, I think. So maybe that's one sort of set of challenges that I'd throw back for discussion.
Pam, your comments?
Yeah, thanks. I 100% agree with everything that Suzanne just said. Maybe I'll just get a little bit more specific about the documents themselves. So, following up on what I was saying before, if I'm looking at how to turn these into a standard or supplement our existing standard with these with this guidance, I would say that the two pieces are like the existing guidance and then these new fact sheets. They're designed to be, I think, and stated to be supplementary or complementary. But I do think there's a tremendous amount of overlap in them. And then in some cases, there's more detail in the original guidance. And in some cases, there's more detail in the fact sheets. And so I'm not sure that I would say the fact sheets are detail that operationalizes the guidance. I think that was kind of the thinking behind it. And that's one of the stated questions from the IPC for feedback. But I think right now, it would be better, the IPC and the people reading this and digesting this would be better served if we could combine those together, because there's a lot that gets repeated. So if I were to send those two documents, for example, to somebody internally at TELUS, they would object to the fact that I just made them read a bunch of things over again. And it would be great if it could be more of a process, like the steps to follow are more in the original documentation, but some of the detail is in the fact sheet. So it'd be better if we could put all of that together and make it a little bit more useful, because I'm not really seeing the conceptual difference between the two in terms of what they are purporting to do or trying to do. That, as I say, there's a lot of overlap, and then I think that would also help clean up some of the terminology differences. The original guidance talks about prosecutor risk and journalist risk. That doesn't even come up in the fact sheets, which are much more focused on sort of identity disclosure, attribute, and membership disclosure. So, really trying to figure out what are the core pieces of terminology that we want to focus on when we're discussing this as an industry, as a profession, and focus on that. But I think right now there's a tremendous amount of jargon between the two of them, and often really helpful and important, but sometimes I think maybe we could pick and choose which are the ones that we think it's most important for those who are operationalizing this to understand. Even just small differences, like in the original documentation, the original guidance, the existing guidance, it says, it talks about data risk times context risk is what gives you your re-identification risk. And then in the new fact sheets, it's data vulnerability times likelihood of attack. Those two things aren't really different. We didn't really change the standard, but we're talking about them a little differently, and I think that could become confusing. So it'd be great to kind of pick one and run with it. Another thing I'd say, I can, I can anticipate if I were to hand this to people in my team, that they would say, well, what, it's not clear to me if these are requirements. Pam, do we have to do everything that's in here? Some things are stated as, as if they are requirements, and the word requirement is used. Sometimes it says should, and then sometimes the fact sheets are kind of almost sounding a little bit distant. Like this is what is often done. This is really describing a best practice, but it doesn't sound like it's prescriptive. So I think it would be great to kind of really go through more conscientiously, like what, are these distinctions intended? Or are they not intended by the IPC? And that would be great to have a little bit more clarity there. I'm trying to think of the other things, just a couple of other little pieces that I worried a little bit about. Documentation with every single data set that gets de-identified. That makes sense. And I think this ties into what Suzanne was talking about earlier. If the paradigm in our minds is large health data sets that are being shared with researchers or potentially public sets, then yes, I understand the need. Boy, I definitely understand the need to document what your steps were to de-identify data. But, I know we've talked as a little group before, like there are lots of times that de-identification, a version of de-identification is happening in our everyday work at a very simplistic level. We're taking personal information, we're aggregating it, maybe we're doing one or two other things, taking out an identifier. It's just intuitive to us how we do that. But I don't think we're expecting, nor should we want, to have to create a record of that documentation every single time we do that. So I think we maybe need to think about some thresholding of when some of these requirements apply. Obviously, any organization has to protect privacy. That requirement never goes away. But to kind of put the burden, the administrative burden of large-scale de-identification on every step, on every aspect of de-identification or every de-identification that occurs is overly burdensome. And then I think the last thing I'd say is just that, it's a small one, but there's another, I think we have to be really conscious of the administrative burden and on organizations and also making sure that we're technologically neutral when we're imposing that burden, like, saying things like we have to produce and archive documentation that actually implies some kind of technology that might be, maybe it's the ability to reproduce it later, but not necessarily produce it and archive it in the moment. So I think we should be aware of the fact that there might be very different types of technology that would be involved. And then what are we asking for in that documentation? One of the things in the fact sheets, I've forgotten which one it was, talked about measuring the risk before and after de-identification in order to demonstrate the value of the measures applied. I don't know that that's really a purpose we need to address. Like if I'm trying to justify why I spent some money to TELUS, I might want to justify the value of the measures I just applied. But I don't know, surely the outcome is what matters here. Have I reached the appropriate re-identification risk level? Not did I change it enough, or I don't think I need to demonstrate to a regulator or to anyone else the value of the measures that I applied. All that matters is what is the end outcome, not the difference between the beginning and the end. And so I think we need to really think about what we're trying to achieve with this guidance and make sure that we're not imposing too heavy an administrative burden that doesn't actually do anything to protect privacy. I'll stop there.
Pam, those are great comments, picking up just from the excellent comments from Suzanne as well. But I want to come back to one, but I just want to briefly summarize. So we had, and we discussed this in prep and internally in Osler team, it just came screaming at us. Just a few of the things that you've raised. One, there seems to be this emphasis in the document. Folks are reading it as really applying to disclosures to third parties, and maybe even with a research bent. Like it seems to sort of overwhelm with that. And what you said, and Suzanne, you really focused on it nicely as well too, is the vast majority of quote de-identification that's been happening for literally decades happens internally in the ordinary course and not in that context. And through that prism, it's really helpful to look at the range of requirements here. And both you and Suzanne said that the circumstances are key. Now, the fact sheet does say you got to make a distinction between internal and external, but it doesn't pop, or at least all the folks that we're talking about, it's not popping. And I wanted to come back to a couple of points you said, Pam, and Susanna, great if you can comment this as well. From a client context, when we get these questions, and we get these questions as a team 4 to 5 times a day, like these aren't happening once in a while. This is one of the most challenging and vexing points that we're dealing with daily on this. When we have the effective guidance, what would we really want? We want a checklist of controls that could be considered depending on the circumstances. And I think what's permeating what you said, Pam, and what Suzanne, you said, is that concept. Like there's elements here, there's elements also within the 2016 guidance, but ultimately what we want, just give us a checklist of controls, distill that for us, and depending on the circumstances, and there's a myriad of different factors into that, you will apply them and consider them. So just before we move on to Marion, could you can you comment on that, Pam and Suzanne? I want to make sure that that's resonating with both of you, because I think it could be helpful feedback appropriately articulated to the IPC.
Yeah, for me, it 100% resonates, Adam. And you know, that is how we approach de-identification at TELUS. So, you know, it's important to understand all of this, you know, the sort of the math and the process, and as I said, almost like a scientific process of approaching this. But at the end of the day, at least the key first initial steps, and what's certainly internally in our guidance, is a list of controls. Here are the things that you can consider applying. This is what we've done internally, to be clear. Here are the things that you can consider doing to your data to either transform the data or to look at other controls like administrative controls, contractual controls, et cetera. And then that allows the business or the you know, the data expert to look at that and see which is applicable in these circumstances. And all of this context around thinking about the recipient, all of that is so critically important. But that first step of here's the list of controls, because otherwise it's overwhelming. If you just say you have to think about the recipient, and you have to think about your re-identification risk, you know, if you're just thinking about it in that academic way, it is absolutely overwhelming. And so that need to just put in front, here are some examples of the controls that you might be able to put in place and to bring down certain types of risk. And I really think that it's very very appropriate to go and map those to like identity, disclosure, the inferences, and figure out what are the risks that you are taking down with those types of steps. But if we don't start with a checklist, it's really hard to make this practical, because that's frankly how I think most organizations work. They follow their process and they kind of go through that checklist, but because context is so relevant, it's always going to be a checklist. It's never going to be, this is the process you follow to de-identify data at TELUS, because it's always different data. It's always a different context. It's always different recipients. So there's always going to be this concept of a menu, and you have to decide based on certain criteria that you might set out in your standard and that you could pull from all of this guidance, which are the ones that apply in your circumstances. So 100% agree. It would be really helpful to kind of map out that process. Like, how do you look at those controls? How do you get that list of, we need that list of controls. And then how do they, as I say, what risks do they address, so that you can kind of get a sense when you're looking at the way that risk is outlined in this document, how you have addressed that risk in that context.
Suzanne, so a checklist of controls to consider depending on the circumstances, just as a concept. What's your thoughts, especially as elaborated so beautifully by Pam?
Yeah, no, like it makes it very practical and very real. And even as you approach other areas, whether it's AI and things like that, it's always about what's the context, and here are the types of things you need to consider depending on the circumstances. And one of the great things about having a checklist of controls is it then allows organizations to say, okay, if you want to take a different approach, I want to directly embed some of these in some of my existing processes. So it sort of almost takes the guesswork out of it. For example, in your privacy impact assessment process, you've got something around, are you using direct identifiers or not? You haven't even talked about whether you need to de-identify. You're asking the question, right? Are you using them?
Right.
If they're not using them, are they direct, indirect? You can get into data minimization. You can ask questions about, is this a new data source or an existing one? We can ask questions, embed questions about, is it leaving a source system going into a different environment? Is it intended to go outside of the organization? So you can kind of build in those controls into an existing process that then takes you, if you like, it kind of can take you to a place where you then need to decide, okay, it's a vendor, is there a third party involved in the contract? And so having that checklist also allows you to adopt different ways and embed them directly into existing processes.
So, and that would address what Pam mentioned and you alluded to as well, Suzanne, about the shoulds and the shalls and some of the like prescriptiveness, et cetera. Because if it's a checklist of controls for consideration in the circumstances, that would, by implication, creating that remove prescriptive things. You must do this, or you should think about this, or other references to that. And I think it would provide clarity. Marion, we've had a discussion thus far about some of the challenges. What's some of your feedback, your consideration, maybe even potential concerns when you reviewed the set of draft fact sheets?
Yeah, and I think, Suzanne and Pam have made so many great points. Certainly a lot of my feedback is very much aligned with that. And I'm seeing a lot of the feedback in the chat as well. So, I think just on a practical point, and it's already been noted, I think there's been efforts to organize the material, by topic and subtopic, but this document is very dense, and even with the cross-references, it can be quite challenging to put all of the concepts together. I personally find the 2016 guidelines more digestible and easier to navigate. But as has been mentioned, a different structure is probably going to be a bit more effective here. And just on context again, while context is mentioned in the guidance, in addition to, the identifiability spectrum and the type of release, I think, these concepts need to be brought together throughout the guidance in a way that supports the practical application of the de-identification process. And for non-public data releases in particular, if the relationship between data vulnerability and context are not consistently made, I think this creates ambiguity, and some of the guidance could be interpreted as requiring a more conservative approach to de-identification than what would be appropriate in the circumstances. And again, for non-public data releases, I think that there is a broader issue of how the guidance fits into the data governance structures of an organization, particularly when data are used for internal purposes. Again, I think, some great points have been made here. Some of these and other controls are touched on in the fact sheets. It's certainly discussed in the 2016 guidelines. But I would have appreciated a more fulsome discussion of contextual factors. Some of these have been mentioned here, but, other things like role-based access standards, confidentiality agreements, retention periods. I mean, there's a whole host of other contextual factors, controls that come into play here. And related to this question of context is that, again, presumably not every internal use of data would be considered a non-public release, or perhaps, let's say, undergo the same process as a release to another organization, but that's not always apparent. I also wanted to touch on some of the practicalities of implementing the guidance. I think there are certain considerations that may be quite difficult to determine in practice. So for example, the motive of the adversary, reasonable assumptions about an adversary's background knowledge, and reasonable assumptions around defining the population. There's a point in the guidance, where the concept of sensitive variables is introduced, and it seems to imply that a certain amount of scrutiny must be applied to all the other variables in the data set, but it doesn't really address how those other variables in the data should be handled. So again, I think that could create some ambiguity. And yeah, I think as has already been noted, some of the techniques, are quite time consuming and challenging, to apply in practice. And even if there are tools available, these tools are also, requiring significant resources to implement. And again, that's not to say we shouldn't do these things, but it just goes back to ensuring that there's greater clarity around when and how to apply the guidance. So in other words, what are the use cases for specific approaches to de-identification? And similarly, I think the section on managing risk when de-identified data is used by the data custodian also raised some questions for me. This is the section that outlines the necessary separations. It's absolutely important to address the separation of duties, roles, and access within an organization. But I don't think that this fact sheet provides a full picture of how risk of re-identification is managed. So if we look at this from the perspective of the identifiability spectrum, different methods and controls, can be used to affect, separations and manage risk across the entire spectrum. So I think we just need to be very clear about what we mean by, identifiable data and how separations are applied in this context.
Yeah,
So yeah.
I think that last comment ties into I think a very helpful discussion we had as in part of the preparation in terms of context. There's the context of, in the circumstances, the application of controls, but there's a broader context that through a whole bunch of initiatives at CANON, we've been striving really to help demystify folks. For whatever reason, the concepts at one level sound so simple, but of all the areas in this privacy law sphere, this might be the most vexing practically. It just, and various reasons. And one of the reasons we've talked about already is it's just loaded with terminology and what many folks perceive as jargon. So we've already talked about like a fulsome glossary would be really, really helpful up front, not just with a few terms. The other thing is what didn't pop, and it's not clear if this is going to be ultimately part now anticipated as the final guidance. What's the context in which this guidance is being put forth? You have, where does the IPC fit with this? Well, the IPC is jurisdiction over several steps, FIPA, MFIPA, PHIPA, the Child, Youth, and Family Services Act. Like they have these oversight functions. Within those frameworks, there's a concept of personal information. And the idea would be that if you effectively de-identify data such that it reasonably can't be associated with Marion or Pam or Suzanne, it would be no longer deemed to be identifiable and outside the scope of that legislative scheme. And just setting that out and then setting out how this ties into previous work effort of the IPC, which has been considerable and predates 2016. To her credit, Anne Kavoukian was at the forefront years before that at putting that together, which is a real credit to the IPC generally. And that would help just frame it. There's references. I think, Suzanne, you mentioned CANON had created this spectrum of de-identifiability. That is a very useful document. Tying that in to that concept is just as you mentioned, Marion, what do we mean by identifiability? Help frame what that means, that de-identification could mean just pseudonymized data all the way to effectively non-identifiable data, and tie that in. And the other point which we had, which I felt might have been one of the most important discussions as part of the preparation was, and maybe this ties into the controls, but tie in that this idea of a risk re-identification framework. Another thing that the IPC is really, I don't know if they coined it, but they certainly were promulgating this early on, certainly earlier than other regulatory authorities. It's a subset of data governance. And I'm interested to hear from each of the three of you. From dealing with each of you, you always articulate it that way. It's not something over here, some technical process. At the end of the day, it's a set of controls that are considered in the circumstances applied within a risk management framework that the organization has, all as part of a data governance. So I see nods. Is that resonating? I think Marion, Pam, Suzanne?
Absolutely. I think this is one tool that fits in with the broader data governance structures within an organization, a very important tool. But, I think as Pam and Suzanne have already mentioned, it's about, when to use this particular tool, versus other tools, and what do you leverage in a particular circumstance. I think it's really important that we kind of bring that together here in some way. I think it's and I mean, we'll get to this in the suggestions, but I think without kind of having tangible examples of, when this applies versus, when other, your other data governance kind of structures come into play, it can be really challenging to make sense of everything.
Let's turn now to the recommendations, because I want to open it up for the attendees. We're seeing lots of comments, some excellent comments from the group. Pam, you've already mentioned some, but if you had 3 or 4 key recommendations to improve the guidance, what would those be for the IPC?
So I mentioned, that I really would love to see this combined with the 2016, and so that we can, make it a single document that has everything you need to know. I think it would be really great, and the fact sheets do this to some degree, but what, after combining, to really consider which portions or fact sheets or whatever the structure is going to be are for which audience, because there are, when I think about who I want to give this to, who I want to train on this, different people in the organization need to know different things. And so kind of thinking about who that audience is, and maybe, the technical, the people who are doing the data transformations maybe don't need to understand all the administrative controls. They need to know that there are additional administrative controls, so that they get the whole big picture. But there would be different audiences. So I think considering that, and I think maybe that was the thinking behind the fact sheets, and I like that aspect of the structure of the fact sheets, that I would really focus it on audience rather than topic. So who needs to know this, and who needs to apply this practically? This is all just kind of selfish on my part, because the degree to which this gets done in the guidance is the degree to which I don't need to then take it and reshape it into standards internally at TELUS. And so to me, that's the best mark of really great guidance is I can just hand this off, and I don't really necessarily need to do a whole lot to it to turn it into a TELUS standard. I've mentioned already that I think we need to consider thresholding, and I saw a lot of people agreeing with that in the comments about when this applies, and that includes that internal versus external, but it might also just include the complexity of what it is that we're doing. Another thing that's just not really in here as much, and I would love to see considered, and it doesn't necessarily have to be in this guidance, but when we think about this as risk, and when you were just asking about sort of data governance and risk assessments, one of the things that will always be considered by an organization, if we're going to share data, de-identified data, we need to understand what's the risk to us if something goes wrong next year, 2 years later, like if it gets re-identified at the recipient's end. And this guidance kind of addresses that very peripheral, like very quickly, and just sort of says, oh, you'd need to like kind of bring it back and notify affected individuals. I'm not sure that I think that that's always going to be the case. And I think that again, we might have a paradigm of health research data in our minds when that was drafted. And so I think a more fulsome discussion about what are those obligations of an organization that has properly de-identified data and passed it along. Is it the same as if we had our own breach or not? And so it really would help with the reticence risk that sometimes accompanies this type of activity when we just don't understand what the risks are of passing it along. So we can say it comes out of privacy legislation. Privacy legislation doesn't apply to it. We share it with another party, but if something goes wrong a year from now, suddenly privacy legislation applies to it. So I think we need to really think, is that what we intend? Is that the right thing? Maybe it is, but I don't know that we've really had, as an industry, as data professionals, fulsome discussions about when that's the appropriate response and when it's not.
Marion, recommendations to approve the guidance.
So, we've already discussed structure, and I completely agree with Pam on that. Having this as a single document would make it much easier to navigate. Really appreciate the comment as well about, the different audiences. And I think it would be, kind of helpful to present, the overarching framework, the processes, use cases, and when the guidance should be employed, at a high level up front, and then kind of have, those technical aspects in separate sections. We've already discussed, the jargon, the terminology. I think that that is a bit of an issue, and perhaps creating a glossary, moving some of the definitions into a glossary or using illustrations and tables for defined terms could be helpful, just in terms of being able to navigate all of this information more readily. And, just as a minor point, but I think, figures are a powerful tool. I think the figures could be improved, and not just to illustrate specific concepts, but, perhaps they could be used to illustrate some of what we're talking about, the relationship of these various concepts to each other, the relationship of de-identification in the context of, data governance structures and other controls. And similarly, I do think that kind of bringing this back to real life in some way could be really helpful. So, use cases, case studies that address the role of context in assessing risk could be, I think, quite valuable, and, how the guidance applies, where other controls are in place. And, it's been mentioned, but I do think non-public data releases in particular can look very different depending on the use case and the manner in which data are accessed or shared. Organizations will typically employ a variety of privacy and security practices to mitigate risk, in different situations. And it would just be helpful to illustrate this in some way, this whole concept of what is reasonably foreseeable in the circumstances, like bringing that to life a little bit more. And then, just kind of, more specific points. I do think that kind of, really consistently making the connection with operational practices and procedures, it will make this guidance easier to implement. I think, there's some inconsistencies. Fact sheet number 10, for example, the checklist, which is great. But, it indicates, as has been mentioned, that there must be a de-identification report for each data set. Fact sheet number 11, I think it is a little bit more tempered, and suggests that this is going to look different for organizations with a standard operating procedure in place. So, if something is a must-have, I think we just really need to be very consistent and clear about the circumstances in which that applies. Just one more quite specific point again, but really looking at this from the perspective of some of the practicalities of implementation. The fact sheets raise a very interesting point regarding the period of validity. And, I think rightfully note that it's quite challenging to mitigate changes in risk for public data releases. But for non-public disclosures of data, I think some suggestions as to how this could be operationalized in an effective and efficient manner would be really helpful. Does this require contractual terms that would apply more scrutiny to the business operations of the data recipient? I just really think that, this section needs to be much clearer about, what would materially impact the risk and provide practical solutions for mitigating any changes in the risk over time, because I think this could be something that's quite hard to pin down.
Suzanne.
Sure. I'm going to come back a little bit to something that Pam was saying, because I think we're both really aligned on the importance, and it is the audience. And sometimes making it clear that this technical section exists and is important, even though I may not be the technical person who's going to review and understand it, but that I know it's being covered, is really important, right? As opposed to having to guess, how am I going to make sure that this happens? And making it clear that there's no expectation that it's everybody who reviews or goes through the document is going to have to make sure that they understand that. But you will connect the dots, and you'll make sure that your technical folks and your model folks are the ones who are reviewing that, or you're the identification experts. So I think that audience is really important. And when you connect it back to sort of formatting, and this has been a formidable piece of work with so much great content. So these are really sort of comments on the fringes almost. I think, how do you take this great content and really make it consumable by lawyers, by data scientists, by policy folks, by business, right? And, it even gets down to the making better and greater use of headings, right? As you're sort of going through it. 11 fact sheets is just really, really tough to consume, right? I'm hoping that there's a different way to do it so that it's really consumable for a bunch of people, large and small, and different expertise areas. I also want to talk a little bit more about the use cases, and we have seen some of that in the chat comments as well. And CANON's done a lot of great work in two areas. Adam, you talked about the spectrum of identifiability, right? It's almost like when you talk to people about what's identifiable versus what's de-identified is actually clearer for people to understand. And yet in our legislation and guidance, we constantly like to use de-identified data, but like a spectrum of identifiability makes it clear when, hey, this information is identified. This information is identifiable because you got to connect it with something else, right? And it's reasonable that it might be connected with something else. And so that allows you to get into your context, right? What's reasonable is if it's in-house on a server that only 3 people have access to, that's very different than data, for example, that's being made available to an external party. And then you have your non-identifiable information, which once again goes down to serious possibility and touches upon the context and the reasonableness and the circumstances that we've been talking about. So, finding a way and we don't own it, right? It's really sort of a best practice out there, and thinking about it in that way would be great, to see if that could be incorporated, because it's been out there for several years now. Also, some of the work that CANON has done with use cases, exactly the conversation we're having now and all of the comments that we're seeing in the chat have really been about context and use cases, right? From the very sensitive, making, for example, health information available externally for researchers and others, all the way through to the other end, which is the less risk, which often is the everyday stuff that organizations do. We've got, 3, 4, 5, 6, I can't remember how many use cases that really tried to address some of those. Now, I know this is Ontario, this is the IPC, and so they're trying to cover off what's in their wheelhouse. But really, and you mentioned it, Adam, really this is national guidance, to be honest, and as the first one to sort of come and pull it all together. And so to the extent the IPC can think of it as national guidance, and try to cover off some of those other use cases, I think just, really reinforces the importance of the guidance and how important it is that, we don't want to see 12 of these, right? We
Yeah.
really don't, right? And yes, there may be another one, right, or two, but the more that this can be seen to be applicable to that broad spectrum of use cases, and that it can be applicable, beyond more than just the health sector or the public sector, right? I think could be very, very useful and would actually do a great service, I think, to Canada.
Suzanne, those comments are great. And maybe just I want to make a couple additional comments and also just summarize some of the other suggestions we actually made in the second part of the discussion. But one of the common themes in the practice is that our clients and contacts are overwhelmed with the sheer volume of guidance, let alone the proposed legislative schemes and all that. So your point, Suzanne, nobody wants, and it's completely unnecessary to have 12 de-identification standards or guidance documents or whatever across the country. So again, it's beyond the scope of what the IPC is attempting to doing here. It's by implication, it's going to be sectorally agnostic, but IPC has a leadership role, very well respected across the country. Perhaps they can consider a process that integrates the other regulatory authorities on this. So we just have one document. We don't need multiple ones. We also, just to summarize, we spoke about the check as a recommendation, a checklist of control considerations to be considered in the context like that. It was the key, effectively a recommendation. There was comments about how the key takeaway documents helpful. One of the things that we did as part of the preparation for this is we went to the 11 fact sheets, extracted the key takeaways and put them in a single document. It will be really helpful for the IPC as they consider it. Does that document of key takeaways stand on its own? Can readers read it and understand things? Because those takeaways are what folks naturally go to. Folks don't want to read 50 pages. All we hear from clients is they're overwhelmed again. They don't have the bandwidth. They want to know what they need to know. So if they go to the key takeaways and that's all they look at, will they be understandable? We spoke, and I think this goes into the considerations, but this was an absolutely critical point. It came up in several of the comments. Avoid the musts, the shalls, don't be overly prescriptive, et cetera. That it's checklist of control considerations. The more this conversation went on, the more I felt the comment about contextualizing this, helping folks who might be new to the area understand why we've been doing this. Why is this important? IPC has this oversight over X. There's the concept of personal information and de-identifiability as mentioned before. There also isn't an express reference, and this came up and it was alluded to in the various comments about, well, how does this align to the ISO standard? How does this align perhaps to some really well-crafted guidance, like for example, in Singapore? What about the PHAC decision, which there's excellent guidance contained, or the IPC's decision 175, which is really helpful guidance. It's what we go to all the time. So tying those things together in a single document, et cetera, maybe as a preamble to a singular consolidated document would be helpful. But we've covered a ton. There's other things that came up on that. I noticed the time, and I want to turn to the second part of the workshop. So first of all, Pam, Suzanne, and Marion, as expected, the comments and insights were superb. So thank you so much for those and just for the time and effort, which I know was considerable in going through that. In moving to the second part of the session, we're going to be opening the floor up for comments, and we're really encouraging for this conversation, but really for the benefit of the IPC, live comments from attendees. And if you don't want to make live comments, a chat comments are welcome. But if you want to make a live comment, and we hope you do, click the reactions icon at the bottom of the page, and then click, there's a raise hand feature, and we'll do our best to call on you. We have a large group, upwards in terms of registrations. We have close to 900 folks. I don't know how many specifically are on the line, but it's a large group. Now, just for clarity, apropos for CANON, we have an anonymization feature on the webinar platform. If you want to make a comment and you want to do so anonymously, you can scroll over the box with your name and image, click on the 3 dots that appear in the top of the right-hand corner. A drop-down menu will appear with a few options, and it says rename. You can select rename, type a new name, and pops up. And if you need any assistance, send a message to the host, and they'll be able to assist you on that. Again, all comments are welcome, but what we're looking for is comments that about the first part of the webinar. We got some great ones already. Were they resonating? Because that will be helpful for the IPC. Do you agree? And critically, if you don't agree, that's helpful for us to hear and why. And then most critically, and I think this is going to be the most helpful for the IPC, specific actionable recommendations for the improvement of the document. That's what Suzanne, Pam, Marion, myself, and a whole team at Osler tried to think through in advance of this. So please think through that. That would be really, really helpful. Now, as a final reminder, before we open it up, this webinar session, again, including the comments and feedback from attendees, it's being recorded. A copy of the recording, together with summary of the key themes arising from the discussion, is going to be submitted to the IPC. And finally, just given the large number of attendees, we're not going to have time to obtain comments from everyone. We'll do our best, but we, again, encourage folks to continue to provide comments in the chat function. So with that, I'm going to turn it over to Caitlin and Catherine. Has anyone raised their hand yet, Caitlin, with a comment? And if you haven't, please, now's the time, and we're looking forward to hearing from you.
I'm not seeing any hands raised yet, but Catherine and I have both been looking at the incredible comments that have been coming in the chat. A lot of great additions and a lot of agreement with some of the comments that have been made by the speakers. So I have kind of moved them into themes, and I can jump into those until we receive a live hand comment.
Yeah, please do. Thank you.
So the first was the recognition of the diverse audience of this guidance. I know this is a point that that a number of people made. So I'll just run through, I think we have about 4 comments that speak to this. So the first was from Jason McWilliam. He says, building on Suzanne's comments, I think the fact sheets should be contextualized for different consumers/readers. Robin Goldsoil says, very important point. It should be organized by different users and roles. Sagar Raharkar says, having a clear RACI is really important here. The role of the Privacy Office and the role of data governance should be clearly articulated. And finally, Sabrina M says, it is also key to highlight that privacy professionals cannot be expected to also be information security technical experts. Rather, they tend to be a supporting role. So I think that's a lot of support for those comments that were made, that this is an excellent document that includes a number of technical points and then some legal concepts built in as well. But perhaps not every individual who's reading these fact sheets will be the right audience for each fact sheet. Any additional comments, obviously, from the speakers on that point? Jump in.
Well, Pam, in the prep session, Pam made some really interesting comments about, and she alluded to it earlier on about, and this picks up from those very comments, where helpful guidance is something, Pam, you were indicating you could just send to your team. You said selfishly, but I actually think it's what everyone in your role would want, right? What we want is guidance that is understandable by a range of folks, the appropriate folks in the organization. And a subset of those folks, it's not about privacy. A subset of those folks, Pam, and it'd be helpful for you to comment on this, are information security professionals on this. And it often gets lost, we find, in the discussion. Pam, can you just comment on that? I think it was so useful when we've had these discussions in the past.
Yeah, absolutely. So, I mean, information security professionals, I think we can find the people who become experts in de-identification in a variety of different roles. Us, historically, it has tended to be in our information security world, but I think as like every other organization out there right now, we're building up our data expertise in terms of, data scientists and data analytics specialists. We're going to see more of that in those teams, which maybe 5-6 years ago barely existed, and certainly 10 years ago didn't exist. So I think it could be in a variety of roles, but certainly security is always going to play a huge role in our overarching approach to de-identification, because there are a number of the controls that will be implemented or assessed by security, in terms of, likelihood of a third party gaining access or the wrong party gaining access. Suzanne just talked about even internally when you're talking about, oh, well, you've got some de-identified data, but only 3 people have access to that database. So that's a control that might be recommended by privacy, but would likely be implemented by security or equally recommended by security, depending on how you divide your roles up in your organization. So yeah, it is a team sport. Like our de-identification approach is by no means solely in the privacy office. Privacy, security, the data scientists, data governance, legal, the contracts, all sorts of different parties. So, just like our approach to AI, it's become very much a team sport. So I think we think about all of these audiences when we get this kind of guidance. Like, how am I going to bring them all along and make them all care and get them all excited to do the right thing? So really helpful when we get guidance that is kind of a nice little. I mean, everybody wants their little guidebook. They want their single resource that they can go to on what they're supposed to do, or at least what they're supposed to consider. So the degree to which we can put that in one place, that's terrific. And then, as Suzanne said, everyone probably needs to see the big picture to really feel part of the solution. But within that big picture, this is the section that you're going to look at when you are actually doing the data transformation. So that's where that, kind of role-based, audience-based guidance comes in. But I think everyone needs to see it all, and most certainly security has a really important role here.
Yeah, just picking up on, sorry, Adam, just picking up on that too, like it allows different members of the team, right, as part of that team sport. It allows different individuals to poke at and ask questions without necessarily knowing, the answer. But then the other side being able to explain it back in a way that those individual team members can sort of understand. And so I think that's why, again, it's really important. And, I've been keeping track in the chat too, and seeing, some additional comments there, and, some comments around, to the extent the IPC feels comfortable doing so, right? Engaging other industries, engaging with other parties to make sure that they too see it as something that's consumable, right? And I think that's a great spot for the IPC to be in. And so, we'll see what happens with that. But yeah, on the team sport thing, it's really important that that it be clear that it's not just one person who's going to be responsible for this when the guidance is issued.
A question for both of you on that, and we struggle with this immensely. It's not just with this, but in all proposed legislative schemes, and this just isn't a Canadian issue. How do we address small and even medium-sized enterprises? TELUS, Sun Life, they're considerably sized entities, and even ICES, while it's not a private sector enterprise, there's a whole focus on analytics that's like leading edge, right? Like it's a different beast than the small enterprise, the physician, the clinic, right? And this is how the recommendation on how to ensure that this is actually going to be actionable for the small and medium-sized enterprise. And maybe part of that is just the checklist of considerations thing. It might be the most practical. It's one that interested, I'm not necessarily putting you on the spot for an answer, but maybe you can come back to on that, because I think that's absolutely critical. I see a hand up, Caitlin.
Yes, Dominic, I'll just unmute you. Oh,
Can you hear me?
Yes.
So I really appreciate this topic on the the topic of these small enterprises with large and complex and sensitive information like mortgage brokers and doctors. So one thing that I'm really interested in here is if the IPC could clearly articulate when de-identification is a prerequisite, specifically for disclosure to regulators, because regulated entities tend to have this sort of impromptu relationship with the regulators, where the regulators can almost knock on your door at any time and say, hey, we want this sort of information, especially in the financial space where they're effectively under what they call continuous supervision. So I think it would be very useful for the IPC to clearly articulate, not just to the regulated entities, but to the regulator, when information needs to be de-identified, because the regulator can very easily view the regulated entity as being obstinate because they're saying, hey, we can't give you all of this because it's identifiable and it doesn't clearly fall into the disclosure requirements under PIPEDA. The example that I gave in the message was the emergency economic measures order. Now I know that was under federal jurisdiction with the freezing of the truckers' bank accounts, but it was something very similar, where the strict adherence to PIPEDA wasn't particularly clear and the need for de-identification wasn't particularly clear. But you know, there is a significant difference in power between a large regulator and a small regulated entity.
And Dominic, just so we're understanding and keeping in mind, of course, the IPC like doesn't deal with the private sector unless there's some integration of the private sector into the health space for the most part. But what are you talking about? Just so we're understanding this, so they can digest and operationalize your recommendation. Are you talking about the IPC in this context having actual access to data? Is that personal information, or is that what you're referring to? Or are you referring to something else?
I'm specifically referring to regulators. When you have provincial regulators that are in contact with regulated entities, both provincial, there's a annex that they need to cross over between PIPEDA and FIPA that is not currently particularly well documented.
Okay. Caitlin, I see another hand up.
yes, Mike.
Tell Alan I just dropped off the posters.
Okay. And we will also mention to Alan that the posters have been dropped off. Okay.
Mike, I think you should be unmuted now.
Yes, thanks. So just to piggyback on Dominic's comment, but I think there's a nexus between data flows where the personal information was collected under PIPEDA in the private sector and then compelled through a series of disclosure requirements to a government agency or regulator that is subject to the IPC's overview and FIPA in a provincial context. So that nexus tracks. I think in the private sector we are more comfortable with those types of data flows. Where I think there's tension between this very welcome, I will say, build on the 2016 guidance is that provincial regulator or provincial government agencies need to be in focus of this guidance, because this guidance will apply to them, and through them will hit entities that FIPA does not apply to, but is a downstream use of data.
Okay,
Thanks.
thank you.
I believe Anita has her hand up as well, so I would just unmute you, Anita.
Hi, Anita.
Hi, how are you?
Good.
This is excellent. One thing that occurred to me throughout the excellent panel discussion and the comments is how the IPC is going to characterize what it produces at the end of the day. So we've heard some excellent suggestions for improvement, et cetera, et cetera. And the concern that I have is, is it guidance? Is it recommendations? You know, even if we get the checklist that folks have seemed to be very interested in, and how that terminology with respect to the deliverable at the end of the day from the IPC is going to impact organizations that say follow it, but then get complaints. And there are issues down the road with respect to, yes, we checked all these boxes, but nobody will disclose the data to us. Or we checked all the boxes and we disclosed the data, and there was a breach on the recipient's end. And I guess I'm sort of looking at this, and my perspective is from the health sector, but from the perspective of data paralysis with respect to organizations being reluctant to disclose, quote, de-identified data to a recipient for research or other types of analysis. So I'm wondering if anybody has any thoughts about that.
So I'm interested in the comments from the panelists. So I think there's two elements to it. One, there's a number of recommendations that have been made, and perhaps a key one being, there'll be a checklist of controls, perhaps, that will be applicable in the circumstances. And how will that help deal with the reticence which currently exists? So that's one part. And the second, and I think this has come up in other comments, but it's certainly come up in conversations we've had internally. How will the IPC actually apply this? I mean, in essence, one would assume that it would be basically articulating in one form or another their expectations. And just by way of example, the 2012 accountability guidance by federal, Alberta, and BC regulatory authorities have a clear preamble in that guidance document, which sets out almost 100 different expectations, how they'll use the document. To your point, Anita, it provides clarity on that, so that in anticipation, if there was like an investigation or an audit, that's the terminology that's used federally in Alberta and BC, they'll look to this as their checklist of considerations. And it's not expressly articulated here how that will be. So I guess Pam, Suzanne, and Marion, especially in the context of being a prescribed entity under PHIPAA, how would you respond to those pieces, that reticence piece, building in some of the recommendations that we've made and that that the panelists have made, and also the expectations from the IPC vis-a-vis this document? Any comments on that?
I think this is a great point. And I think, as you know, I and some of my colleagues reviewed this document, I think the same questions came up. Goes back to, what is a must-have, versus what is a best practice. It very much goes back to the question of, what are the implications of, implementing some of these? I think I mentioned it around, the period of validity, or these kinds of requirements going to create a chilling effect. And so I do think that we need some clarity on, what kind of the threshold is. But, going back to the broader, discussion that we had around, when to apply, specific aspects of the guidance, I think it's very much related. Because, I think it's being set up in a certain way where it's not always clear, when you really need to be applying, the specific, procedures, if you will, or processes that are outlined here.
Pam, Suzanne, do you have comments?
Not really much to add per se, other than, the expectations around the use are really important. It is being issued as guidance, right? And I think it connects back to some of the comments around it not being prescriptive enough, but not too prescriptive, and the use of must versus shall, right? Because again, that kind of goes to expectation, right? That the terminology you're using, and so having use cases in there and making it clear about the context and everything, would help, I think, with that expectation. But it'll be interesting to see what the IPC actually comes out with on. But it's clear they're issuing it for a reason, right? And let's make sure it's the best guidance it can be.
What one would anticipate that, let's say, an output of this in the updated guidance, there is a crisp checklist of considerations, not must-haves, considerations depending on the circumstances to be applied. And there's alignment on that and supplementary explanations of what those mean, et cetera. One would think that that helps to reduce reticence because it reduces ambiguity. It gives a sense to organizations of the suite of things they have to at least consider. And if they appropriately check off the box with due diligence on each of those, and it's the appropriate team members who do that, one could think that it would reduce reticence, which would be excellent, to one of Anita's points on that. So that's what struck me from the potential of the guidance, while it ultimately might be very, very impactful. We know that when organizations are under investigation and these things come up, it would be extraordinarily helpful to have a checklist from, in this case, the IPC, and to be able to cross-reference. See these 15 things or 10 things? Like, we did every single one of them in one form or another. Maybe it wasn't perfect, but it was pretty damn good. And so that you're not going to be held to task, and sometimes unfairly so. I'm not saying the IPC has been unfair. I'm just saying these things can happen and take on a life of their own. So having this checklist of considerations one would think would be very, very helpful in that regard. But I guess that would remain to be seen. Caitlin?
I was
Yeah,
just
go
going to
ahead.
follow up on that, Adam. I mean, I think, it's probably obvious to say, like, any certainty can help in terms of reticence risk, because uncertainty certainly leads to reticence risk. Well, maybe I'm going to go back on that a little bit and say uncertainty leads to reticence risk. But if there's a certainty of, the wrong threshold, and, and Marion kind of talked about that with maybe this validity period, or if we think that, there's just far too high a burden, or a lack of clarity around what, that downstream, what happens if the recipient or the recipient's recipient has a breach, what's the accountability? If we can't quantify that risk, then that will be a problem, and that will create reticence risk. Like, if I can't quantify the risk to our business about, the impact of doing something or not doing something, then that's going to be a very scary thing. And I think the more that we can have that certainty, that will also address that early, the earlier comments around small and medium business, where there's uncertain guidance. An organization the size of TELUS or Sun Life, we can fill it in. We can do belt and suspenders, and we can put we can throw every possible control at it, because, wow, we really want that ROI, and we're gonna go after it, and we're gonna make sure we've protected privacy. But a small and medium-sized business cannot throw every resource at it to make it happen. Doesn't necessarily have the expertise in-house, so they need more of that sort of more prescriptive checklist. Not prescriptive as in, like, they have to do single thing on it, but, like, if I do these things, I'm going to be okay. And I think the extent to which we can create, like, guidance can be created that will do that, then I think that will address, certainly will address risk in the big organizations, but I think will really help with those small and medium-sized organizations as well, because they're the ones, I think, that suffer most when it's not super clear, because the rest of us can go in and invest and get that ROI, but they can't. So either they're suffering from reticence, or they're taking risks they shouldn't take.
Caitlin, anybody else had their hand up?
Anita, I believe you had your hand up as well for a follow-up.
Yeah, I just wanted to pick up on something Marion had said that occurred to me. That's becoming, I think, an increasing problem or challenge with respect, and we've heard this, with respect to various organizations in a particular sector, and I'll speak of the health sector, that are subject to 2, 3, 4, whatever pieces of legislation. And perhaps with respect to whatever recommendations are made to the IPC on their consultations on DID and the related matters, that there is a specific recommendation that they consider certain use cases with respect to other organizations subject to different privacy legislation and what de-identification, identifying, et cetera, means. Because while this is certainly going to be helpful, it's potentially going to become more difficult for those organizations and entities that are subject to different pieces of privacy laws.
Yeah, that's a good point. Caitlin, other comment?
So firstly, I just want to mention that Jason McWilliam had a very similar comment to what we had been discussing, where they say, I think it's important that the IPC describe how these fact sheets will be leveraged by the office in their oversight and adjudicative activities. So I think there is definitely an interest in understanding the purpose of the guidance and how it will be applied in that way. And then just a few people who really showed their support for a checklist. So Anne Levine said a checklist would be great, as well as more examples and case studies to illustrate different approaches. Elatus Figueredo said, I like the idea of the checklist of controls, particularly when addressing certain types of uses for anonymized data in contracts with vendors that may fall under various jurisdictions. Robin Gould-Soil says the checklist should be associated with the use case / circumstances as well. And Sebastian Pa says it would be great if the sheets were easier to navigate. What steps do I need to take? What standard do I need to meet for my particular situation? I just wanted to run through those, and then to pick up on what Pam was talking about, going back to the challenges with operationalization by different sizes of organizations and industries. So Chris Wilshire says, Pam's point on administrative burden is especially important when considering different sizes of organizations. It needs to be easy for smaller orgs to apply based on their capabilities and available resources. Natalie Como says, Pam's comments on setting a threshold for documentation are very relevant in public organizations who perform / practice de-identification daily or hourly by all types of people within an organization. And then Carol Garmet says, the documents provide for a customized assessment of every data element in every data set. My concern is that public hospitals in Ontario do not nearly have the resources to follow the processes outlined, and certainly not every time that we use or share data for any purpose. Is there any thought to requiring this type of assessment for some types of data sharing, but certainly not for all, which I think goes back to context being king. I'll pause there. See if anyone wanted to add any comments on that.
Yeah, and it goes to a broader public policy issue. It's not just for the health sector. I think it's or the broader public sector. It's for small enterprises anywhere, but especially in the broader public sector that are for data intensive entities. There are these cost considerations, and this guidance, however crisp and helpful it will be, will not solve that issue. And so some thought from the IPC how beyond this efforts it could take in terms of their dealings with stakeholders, and for those folks on the line who are involved in dealing with the government and hopefully and I know there's members of the government here, just taking that to heart, because you have 3 extremely responsible data stewards who have been speaking with excellent comments. and everyone wants the right outcome, but there is a cost consideration here that has to be taken into account. And this small applicability of this to being operationalized by small enterprises is going to be more and more of a challenge if this isn't tackled in some way. And it won't be tackled by the guidance document. It just won't. It's beyond that.
And back
Any other?
Oh,
Yeah,
sorry.
go ahead.
I was just
No,
going
go
to say, back to the reticence risk and it actually being a barrier. Justina McFadden mentions that she's very concerned that strict adherence to the standard in every case will be a barrier to a hospital being able to conduct meaningful activities, including QI, research, education. So I think that's another really good point in terms of public policy and the beneficial uses of data.
Yeah, that I think like the dominant theme is this checklist, but applicable. It's things to consider, controls to consider, depending on the circumstances. Our healthcare system, we know, is in crisis. Leveraging of the data is a critical part of the solution for that. And if you create, like, if it unintentionally creates barriers, directly or indirectly, it's going to be a challenge. Are there anyone else have their hand up?
No hands up right now, but I can move on to another point that was pretty thematic across a number of individuals' comments, which is there remains this definitional confusion that seems to be prevailing in spite of the initial fact sheet 1. So it demonstrates that need for a clear glossary that a number of the speakers mentioned.
Yeah.
Chris Wilshire says, making the glossary work across multiple jurisdictions would be helpful too. The more consistency we can have will make it easier for organizations to apply and communicate these guidelines to their respective teams. And of course, as many people know on this call, different statutory regimes use de-identify differently than other statutory regimes, which use the term anonymize. Which brings me to Jeff Curtis's comment, which is, it seems like the term anonymization is effectively dead. Is that a generally accepted concept across various industries? And I think going back to certain comments that were pulled out of the guidance, there is this acknowledgement of it not being zero-sum risk. So there is acknowledgement that absolute anonymization without any risk of re-identification is not the threshold that we're seeking. It's just that confusion around terminology. Anonymize is akin to de-identify when it's used under PHIPAA. And then finally, Audrey Deschênes-Renaud says, in which context will de-identification be acceptable versus anonymization? Different jurisdictions have different interpretations. So maybe just speaking to the glossary point and clarification on that.
Yeah, I think Jeff's point's excellent. Like, and we've had so many discussions at CANON about the term anonymization, and we sort of default to de-identification for the exact reason that Jeff was mentioning. The problem is certain statutes, at least draft or the regulations in Quebec are another example, they use that term. So there is guidance, including there's ISO and other guidance that was mentioned earlier on. So in the glossary clarification, how the terms align to sort of equivalent terms, I think would be probably a very, very helpful step. That's a great point that were made by the two folks. Anybody else's hand up, Caitlin?
Not currently, no. Just taking a look through some additional comments that were made. Again, back to sort of the public disclosure versus internal use. Sabrina M mentions if the organization shares de-identified data to a third party and the third party also receives additional de-identified data from another organization that allows for re-identification, is the risk on the organization who shared it or on the organization who gathered it, which I think reflects just that additional point on reasonable in the circumstances and getting into those risks of public versus internal use cases.
Yeah, and it seems we may have come to the conclusion of getting new additional comments, but I at this point, so maybe what we will do is just cut off the conversation right here. First and foremost, again, I can't thank enough, and I think I know I speak on behalf of everyone who attended the session. Pam, Suzanne, Marion, your comments were superb. And it's so helpful to hear from folks who really, really know their stuff. And from organizations who just really want to do the right thing. How like comments about this, I think it's so helpful. So thank you for the time. Thank you for the in terms of this event, but really the preparation for that. And most critically, thank you all who attended. We had close to 900 folks who registered for the event, and we really appreciate, I think the IPC will be very appreciative as well of the tremendous interest in the draft guidance. And hopefully the IPC found this conversation, I certainly did, hopefully they find it very helpful and valuable. And as mentioned earlier on, as part of the next step, we're going to digest this. Or this recording is going to be submitted with a thematic outline, thematic comments, some of the recommendations, etc. Everyone who registered for the session will receive a copy of our submission to the IPC. And last but not least, as we head into the holidays, I wish everyone happy holiday and all the best for 2025. And we look forward to seeing you all at future CANON events. Thank you.
Thanks, Adam. Thanks, everyone.
Thank you.